The plucky YouTubers behind the channel MxR Plays claim that they're being extorted by Jukin Media, all for uploading some reaction videos to YouTube. On the other hand, Jookin says that MxR committed copyright infringement by using their videos without permission. Who's right? Well, I have some good news and some bad news for MxR. The good news is that they might have a defense to Jookin's claims. The bad news is that they might not have a defense. I have worse news still. They might not just be liable for the $6,000 that Jookin demands, but actually $600,000 or more. And the worst news of all, there's no way to figure out which one is right until they go to court and spend potentially $1 million on attorney's fees. So who's right in this whole reaction video debacle? Well, let's think like a lawyer. Hey LegalEagles, it's time to think like a lawyer because I've received hundreds of emails and DMs about this particular case and this particular video. This case has it all. A little guy who's getting pushed around, a bad guy who might be a troll, the intricacies of copyright law, huge stakes, and thousands of teenage legal experts. So let me give you a quick summary of the facts as I understand them because they're going to be necessary to make any kind of legal judgment here. A few days ago, the YouTube channel MxR Plays posted a video to YouTube claiming that they were being extorted.
Something called Jukin Media. Sorry, it feels kind of weird talking about it because it just happened.
Apparently, a few weeks or months ago, they have been posting various reactions on their channel. They would take viral and meme video clips from the internet, and the two of them, I assume that they are a boyfriend and girlfriend couple, would react to them in some ways. Sometimes it would be the man that was responding and reacting to the clip. Sometimes it was the woman in MxR. Not unlike many YouTube channels that are out there reacting to various clips. Now, as it happens, a company called Jukin Media claims that the couple used clips from Jookin's database. And Jookin appears to be sort of a middleman that goes about clearing rights to various viral clips. If they see that a video is trending, they'll go out and they'll reach out to the person that created the clip, and they will get the ownership rights to these various clips so that they can license those clips to other people.
It used to be that they would claim your videos and take the revenue from that video, right?
Better than a strike.
Yeah, and so we started, removing their clips from our videos.
Of course, because we're like, okay, that's your clip, so we won't use it.
Yeah, so basically they just strike our channel now whenever they see a clip.
Some call Jukin Media a middleman. They themselves analogize to Shutterstock, where they buy rights to various forms of media and then sell it to other third parties. Generally, you can buy a license from Jukin on their website to use their clips for $49 per clip. Some call Jukin Media a copyright troll. They specifically get viral clips so that they can extort money from other third parties. I won't make a judgment call as to whether they are doing a good thing or a bad thing for the internet. But in this particular case, it appears that MxR admit they have used various clips that belong to Jukin. I don't know if Jukin actually owns the rights to these clips, but for the sake of argument, let's assume that Jukin does in fact own the copyright to these various clips. In the past, Jukin has reached out to MxR and they have demanded $2,000 from the couple for the couple's use of various Jukin clips in their YouTube channel.
They email us with a bill and they charge us $1,500 per clip that was in our videos. And so today we got hit with a huge bill of $6,000 in total.
Jukin came back and demanded $6,000 more for the use of 4 other clips that they didn't previously make a demand on. It was at that point that MxR went to the internet and, as one does when they have a YouTube channel, posted a video saying that they were being extorted by Jukin for $6,000.
So we've paid about $2,000 in total, and now we have another $6,000 to pay. And if you don't pay, then basically they'll start striking your channel.
MxR claims that their use of these videos is fair use, of course, and Jukin disputes that characterization. The stakes here are incredibly high in several respects. Number one, Jukin is asking for $6,000, which for many households, that amount of money could lead to financial ruin. But additionally, when you get attorneys involved, $6,000 is a drop in the bucket, and we can be talking about hundreds of thousands of dollars here. But on top of that, still, we're talking about copyright strikes here, and Jukin has threatened to issue copyright strikes against MxR, which means that with 3 copyright strikes, potentially MxR's entire channel could get deleted forever.
Basically go through our entire video library, most likely find 3 instances of some, random clip, and then they'll basically remove our channel. if we don't pay them.
And we don't really have power against it. Like, we're stuck between a hard place and a rock. So I feel like they're just constantly gonna extort us.
So the stakes are incredibly high, which, by the way, is why I created a course for creators called copyrightcourse.com to deal with this exact situation of where you are threatened with copyright strikes and what to do if you do get a copyright strike on your channel. So let's talk about this exact situation and the law that governs this potential dispute. Now, first a disclaimer, I don't know all the facts. I've gotten some of the facts from MxR, which are going to be necessarily biased. I've gotten some of the facts from Jookin, which are also going to be necessarily biased. I don't know all of the facts, but one of the good things about copyright law is that often it just depends on the underlying works themselves, which we can look at and we can analyze. So let's talk about copyright law in general, and specifically the copyrights. One of the biggest myths on the internet is that if something is out there, you can use it for almost any purpose. That's absolutely not the case. If there is a clip on the internet, someone owns it. It might be hard to track them down, but that clip, whether it's a video, a sound file, or a picture, they belong to someone. And the default position of copyright law is that you need permission, a license, to be able to use that underlying work, whether it's a picture or a video or what have you. However, there's an exception to that general rule that if you use that media in a fair use way, you don't need to get permission, and you also don't have to pay a license fee. But if it's not fair use, you do have to pay, and the rights holder can block you from actually using that underlying media. Fair use is incredibly complex. Even judges get this wrong, and often judges say this is the most complicated portion of copyright law in all of jurisprudence. But if you go to 17 U.S.C. 107, you will find the fair use factors to determine whether you're using something in fair use. The fair use clause states that notwithstanding the rest of the Copyright Act, for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright. And in determining whether the use made of a work in any particular case is fair use, the factors to be considered shall include 1, the purpose and character of the use, 2, the nature of the copyrighted work, 3, the amount and substantiality of the portion used, and 4, the effect upon the potential market or value of the copyrighted work. So let's talk about that really quickly. So the first part of this section of the Copyright Act says that generally, things that are for the purpose of commentary and criticism can be considered fair use. Now, that's not dispositive, but in order to get to the rest of the factors, you generally need a purpose that is recognized by the fair use statute. Now, that's not an exclusive list of the things that qualify as fair use, but for intensive purposes, let's assume that that's the entire universe. Now, there are 4 factors to determine whether the actual use itself is fair use. Now, these are factors. They're not elements. You can't just check them off, and you have to balance every single one of them. And just because you win one factor doesn't mean that the use is going to be fair use. You have to balance all 4 together, and the first factor is by far the most important. Now, this is going to be a gross oversimplification because there are literally millions of pages written about fair use in American jurisprudence. A quick summary of the first factor is that this looks to the transformativeness of the use. Assuming your purpose is recognized by the fair use statute, let's assume commentary and criticism, because that's what most YouTube use of media falls under. Sometimes it's parody, but usually it's commentary and criticism. The first factor looks to whether you have transformed the purpose of the original clip itself. So for example, a movie review. A movie review often uses clips from the movie that it is reviewing, but it would be very, very difficult to be able to have a coherent criticism or to be able to comment on a movie without being able to use small portions of the movie itself. But how does a movie review transform the underlying movie? The purpose of a movie, generally speaking, is for the entertainment value. You watch a movie because you're there to be entertained. But a movie review itself is not for the purpose of entertainment. You're not usurping the original purpose of the movie. You are making a movie review specifically to create commentary and criticism about that movie. That is what we talk about when we're talking about transformative nature of fair use. And that's why the Copyright Act specifically carves out commentary and criticism as a fair use. So that is the fair use purpose plus the character of the use, which is transformative. The first factor is by far the most important, and you can overcome a lot of sins in the other 3 factors if you have a highly transformative use case with a clearly fair use commentary and criticism purpose in your use. So that takes me to the second factor, the nature of the copyrighted work. This generally looks to whether the underlying work itself is factual or fictional in nature. Copyright doesn't want to give people a monopoly over facts. So as a result, factual works, things that actually happened in real life, tend to get less protection than things that are fictional and highly creative. This tends to be actually the least important of the four factors. Factor number 3 looks to the amount and substantiality of the portion used in relation to the copyrighted work as a whole. This is often summarized by saying that people are only allowed to use the minimum amount necessary, the bare minimum, to be able to get their commentary or criticism across. So just because you're giving commentary or criticism doesn't mean you're allowed to use the entire portion of the underlying work. Sometimes you are. Sometimes the clips are very short. Sometimes you're only dealing with a picture, which you kind of have to use the whole thing. But the bottom line is that you generally can't use the entire work itself, or you can't use the heart of the work itself in order to form your commentary or criticism. And finally, that takes me to factor number 4, the effect of the use upon the potential market or value of the copyrighted work. This is actually pretty similar to the third factor. The idea is that we don't want people using things in a fair use way that usurps the entire market for the original work. If people are going to watch your video and not watch the original video or not pay a license fee to the original, then that's a factor that cuts against your claim of fair use. And that also kind of overlaps with the first factor as well, because the less transformative your use, the more likely you are to use the original purpose of the underlying work, and the more likely you are to usurp the potential market for the underlying work and degrade the value of that copyrighted work. Now, if this all sounds incredibly squishy and ambiguous, you are entirely right. That's sort of a feature, not a bug though. The purpose of fair use is that this ambiguity and the fact that it's squishy leads to flexibility. So we can carve fair use into whatever we need it to be, and we can apply it to new situations. It's quite flexible. The problem is often you have to go to court to be able to adjudicate these things. And it also means that there are absolutely no absolutes. You can't say that all reaction videos are fair use. Some are and some aren't. It depends on the facts of the particular case. So now that you have a reasonably good understanding of what fair use means and its limitations and its ambiguity, let's look at the videos that MxR actually used and which Jookin claims that MxR now owes them thousands of dollars for having used. What MxR tends to do is they will take the general clip and then they will inset their own video in a small portion of the rest of the frame. They'll play the entire clip, it seems, and then they will react to it. So apparently Jookin sent MxR a demand letter that referenced 4 Jookin-owned videos that were used in 3 MxR reaction videos. On that basis, Jookin claims that MxR owes them $6,000. So let's look at these different videos. So the first video that is at issue is them reacting to a video of a cat sticking its tongue out. It's only a couple seconds long. I'm gonna zoom in on MxR because I don't want to infringe the copyright of the cat video owner.
Aww, it made me forget about the mayonnaise and the maggots and the...
So you can see it's an incredibly short clip and there's very minimal commentary and criticism, if any. Generally speaking, in copyright law, you have to comment and criticize the actual clip itself. You can't use the clip to comment on something else. That's kind of the difference between parody and satire. Parody comments on the underlying work, satire comments on something else. Parody is fair use often, but satire is almost never fair use. The next video is of MxR reacting to a volcano exploding.
Oh, that's cool. Whoa, you see the shockwave?
Watch out for the shock, it's coming.
Did you see it? Dude, that was awesome. Wasn't that awesome, Genie? That was so awesome. Do you want some water?
So you can see here again, they're only playing a small portion of this volcano video, but arguably that's the heart of the volcano video. You're not gonna watch the 20 minutes of the volcano not erupting. The thing you wanna see is the volcano erupting. And the commentary, if any, is basically "that's cool," which is about as minimal as it gets. Now, in this third MxR video, it appears that they've edited it to remove the Jookin videos. I actually couldn't find the videos that Jookin references in the demand letter. I wonder if they have edited those out, or maybe I just wasn't paying attention. Jookin references a girl doing a backflip and guys lighting a trail of leaves on fire. I couldn't find that in this underlying video, but I do want to reference what MxR says at the very beginning of this video.
So it's time once again to get Genie to laugh. I've come up with yet another brilliant compilation of funny things, all in the worthy endeavor of making my beautiful darling girlfriend laugh because she deserves happiness.
Sparkles!
They point out that Henry is showing Jeannie these different videos to see if he can get Jeannie to laugh. In my estimation, that's not really commentary or criticism. That's not a transformative purpose. And in fact, by showing those clips in full to the audience, arguably they're using the clips for the exact same purpose as they were created in the first place, to entertain people, to try and get people to laugh. And it's entirely possible that you might not watch the Jookin videos because you saw basically the whole thing in MxR's videos. So some of those fair use factors might cut severely against MxR's claim of fair use. It's hard to say because we don't have those clips in this particular video, and there might be more or less commentary than in the prior two videos that we looked at. Now, the last thing I want to point out is that in the beginning of this video, Henry says that he's not going to display the audio of a particular clip, not a Jookin clip, I don't think, but another one because he's worried about getting a copyright claim related to the music. And that is bad when you're talking about potential willful behavior, which is an issue when it comes to damages that we'll talk about in a second. So there are a lot of bad facts in this particular video. In fact, some of these clips might be dangerously close to a hypothetical that I use when I give speeches about copyright and explain things to creators. An example of something that you might think is fair use that is clearly not fair use. The example that I come up with, and this is not an actual case, this is just me hypothesizing, is that we recognize that movie reviews are often fair use, often quintessential fair use. But imagine if you had a movie review that had the entire movie itself, the entire 2-hour-long movie, and then at the end of the movie reviewer said, yeah, that was pretty good, or I didn't really like that movie. You've got commentary and criticism, you've got some sort of criticism about the movie, it was good or it was bad. But because you use the entire movie itself, that's clearly not the minimum necessary. And the commentary itself is also just about as minimal as it gets. So the question of whether MxR, Henry, and Jeannie are actually doing something that is fair use commentary and criticism or copyright infringement may turn on how courts have looked at reaction videos in the past. So let's look at some of those cases. And this is hilarious because one of those cases involves Jukin Media itself. Before we get to that, let's talk about my favorite fair use case of all time, and that is the H3h3 Productions case. In that particular case, Hilla and Ethan Klein, the comedy duo behind H3h3 Productions, did a reaction video to a video of a man named Matt Haas. There was something along the lines of parkour girl versus workout guy, which is a pretty cringeworthy thing where a guy kind of stalks a woman who's working out on the street. And in that video, they use almost all of the entire clip itself, but they are also peppering the 10-minute long video with lots and lots of commentary. The Southern District of New York, which is in the news for many different reasons, sided with Hilla and Ethan and said that this is a quintessential commentary and criticism and quintessential fair use. And so they threw the case out. Now, it was a bit of a Pyrrhic victory because that required hundreds of thousands of dollars from Ethan and Hilla Klein to be able to get to that stage of adjudication. And that was taken out in a very early stage on the motions, as we say in the legal field. It didn't even go to trial. So if you go to trial, you can expect to pay 3 to 4 times as much. I mean, honestly, $800,000 to maybe $1 million to be able to adjudicate that. So that takes us to the =3 versus Jukin Media case, a case that actually involves Jukin Media itself. This is a case that is pretty similar. You have a YouTube clip show that is owned by =3, and they are reacting to a particular clip that is owned by Jookin. This case involved close to 20 different clips, but here's one that is sort of emblematic of the rest of them. Jookin owned a video of a bear getting its head stuck in a bucket, and some construction workers used a crane to get the bucket off of the bear's head. The clip show used almost all of the clip itself and then proceeded to talk about it for roughly about a minute.
Every time a bear gets his... Oh God, Winnie the Pooh, it gets me.
And regarding this particular clip, the court sided with =3 and found that this was in fact fair use. If you were to ask me what is the case that shows the absolute bare minimum of commentary necessary to make a fair use claim, I might point you to H3h3 versus Jukin Media, which is why I have cited to that case in almost all of my videos that rely on fair use clips. But this case is a bit of a mixed bag. The court decided as a matter of law that most of these clips were fair use, but also decided that some could not be adjudicated, so those would have to go to a jury to decide, and at that point the parties settled out of court. So it's a bit of a mixed bag, and Jukin might have been right on some of those clips. Now, if you want an in-depth analysis of the H3h3 versus Jukin Media case, check out my friend Leonard French's channel. He goes into a huge amount of detail about this particular case exactly. The bottom line is that this would be an incredibly close call. MxR is skating dangerously close to the line of it being not fair use. But there's authority on both sides. In fact, one of the cases that I would use against Jukin Media if I was representing MxR is a case involving Jukin Media itself. But arguments can be made on both sides. If I was representing MxR, which I'm not your attorney, and this is not legal advice, I would advise them not to go to court because I'd be worried that number one, they would lose, and even if they won, they would probably have to go all the way through trial and take it to a jury, which would incur potentially $1 million in attorney's fees. And by that same token, stop admitting to Stop going online and admitting not only to liability, but potentially evidence that could give rise to liability. Stop posting videos and stop going on Twitter and lawyer up and talk about what your rights are before you start digging yourself into a bigger hole than you already have. On the other hand, if I was Jukin Media's attorney, which I'm not, this is not legal advice, I would probably tell them the same thing, that this is not something you'd want to go to court over. They've lost on this before, and that you're dealing with potentially not only losing this battle, not only in court, but in the court of public opinion, but potentially attorney's fees are on the line. One of the things about copyright law is that sometimes the loser has to pay the winner's attorney's fees. It gets really dicey. I don't know that this is one of those cases, but it could be on the line. But there are bad facts and there's bad law for both sides. This is not something that either side wants to take to court. And the stakes are incredibly large. I talked about earlier that MxR might be on the hook not just for the $6,000 that Jukin requests, but actually $600,000. The reason is that when you're talking about copyright law, not only do you have to deal with what are called actual damages, the out-of-pocket loss that someone has suffered, but you also have statutory damages. And in some circumstances where you have a willful act by the copyright infringer, you can get $150,000 per infringement. So those 4 different videos that may or may not have constituted copyright infringement could mean that MxR was on the hook for $600,000 in statutory damages. That would be up to the court. On top of that, attorney's fees are on the table as well, which might even be more than $600,000 if this was taken to court. Not to mention, since we're dealing with DMCA takedowns and YouTube strikes, that their channel might be deleted, which I assume is their major source of income for the household.
It's just constantly in the fear of our channel being deleted.
So given the thousands, potentially millions of dollars at stake, is this extortion by Jukin Media against Henry and Jeannie at MxR? Well, almost certainly not, at least not the legal definition of extortion. This might constitute the sort of colloquial understanding of extortion, of a bad guy pushing a small person around, but it's almost certainly not legal extortion. We'll talk about whether Jukin is a copyright troll in a second, but in general, to be able to form a claim for extortion under at least the federal statute in 18 U.S.C. 1951, you have to have a wrongful claim. It has to be disconnected from a claim of right. Jukin claims to have a good faith belief that this is copyright infringement. And on the facts as I see them, they could very well have a meritorious copyright claim. It's hard to say, it could go either way. But because of that, essentially what they're doing is they're just making a demand, which potentially is legal, against someone who is a potential copyright infringer. Jukin Media actually left a comment on MxR's YouTube channel saying, "Hi, we'd like the chance to respond to this. For starters, it's important to understand that we provide a service for video creators. We allow them to list their content on our website so that TV shows, publishers, YouTubers, influencers, or advertisers can buy a license to use their content. We have no ill will towards you or your channel. In effect, you're taking other people's videos without asking them, then posting them to your channel and making money off of them. We never want to issue copyright strikes. We have a duty to do so to protect the copyright of the creators who have signed with us. Again, there's no reason we can't work together so that you can have access to amazing videos and that creators of those videos share in the economics." Of course, Jookin says they don't want to issue DMCA takedowns, and the reason is because there are actual legal repercussions for levying those DMCA takedown notices. So, of course, they don't want to do that, and they don't want to take people to court because it's incredibly expensive, and they might lose. But that's why some people call Jukin Media a copyright troll. They get the copyrights to various viral videos and then make demands for serious money from people that have used those clips in other media. I reached out to both MxR and Jookin about this particular dispute. Jookin got back to me and provided this statement. They say that they did consider fair use, but they feel that MxR's videos don't rise to the level of fair use, and that they point out that they have paid out over $20 million to people whose videos they have licensed. But we don't know what percentage of Jookin's revenue comes from making these demands versus proactively licensing this material. And in some sense, having middlemen like this can be a very good thing because it's often very, very hard to know who owns the rights to these various things. Someone owns the rights to these viral clips, but often big businesses will not use them because they might not be able to track down who owns them. And having a middleman like Jookin can help solve that problem and create revenue from licensing that otherwise simply wouldn't exist. Now, if you want more detail about whether this constitutes extortion and the requirements for extortion, I recommend checking out fellow YouTube lawyer Richard Hoag's channel, where he goes into a lot of depth about this. Now, I disagree with him about the dollar amounts themselves being potential evidence of a claim of extortion. Just actually, $1,500 per offense is a pretty small amount, if I'm honest. I know it can be a huge amount to small YouTubers out there, but in the world of copyright law, it's a very, very small amount, and it is dwarfed by the potential devastating effects of statutory damages or an award of attorney's fees in an actual lawsuit over this case. One of the more famous extortion cases is the case of Autumn Jackson and Bill Cosby. Autumn Jackson claimed that she was the daughter of Bill Cosby before he was outed as a sexual predator, and extorted him, said that she would ruin his squeaky clean reputation in the news media by sowing these potentially untrue allegations that he had fathered her out of wedlock. And one of the cases that Richard Hoag mentions in his video about this case is the Michael Avenatti case. This is ongoing. It hasn't led to a resolution, but one of the things that Michael Avenatti is accused of having done is to extort a settlement out of Nike, not for his client, but for a multi-million-dollar consulting gig for himself. Lawyers are not allowed to negotiate on their own behalf at the expense of their client. And so that could conceivably give rise to extortion. Michael Avenatti just lost a motion to dismiss that legal claim, so it's going to go to trial. We'll see if he's convicted on that. But when a lawyer tries to get something from a party that they're not legally allowed to ask for, like a consulting gig worth millions of dollars for their own behalf, that could potentially give rise to extortion. Whereas here, mainly what's happening is that Jookin is asking for payment for copyright infringement. And as we've talked about before, whether copyright infringement occurred or not, or whether it's fair use or not, is certainly an open question. By the way, some have said that YouTube should just shut this down. Jookin is abusing the copyright system, regardless of the underlying claims, and that YouTube should just remove their ability to make these claims. Well, the problem is this isn't really YouTube's system. This is not Content ID. What Jookin is talking about here is issuing a DMCA takedown. This is written into the Copyright Act, Section 512. If there is infringing material on a website, including YouTube, you are allowed to issue a DMCA notice and have it taken down. YouTube has implemented a version of that which incurs a strike when you get a DMCA claim. But there are also ways to fight DMCA claims, which I've covered in my copyright course. So effectively, YouTube has to follow the law. When they get a DMCA claim, they have to take the video down. They can't ignore it, and they can't stop people from issuing DMCA claims. It's written into the copyright law that they just basically have to follow. And if Jookin does actually have a claim, then they have every right to issue a DMCA takedown. Now, the Ninth Circuit law under Lens says that they have to have a good faith belief that they have a claim of copyright infringement, and they have taken into consideration fair use before they have issued that DMCA takedown. But look, if they have a claim, they have a right to issue a DMCA takedown in a copyright strike. This is serious business. I get copyright claims all the time on my channel, but I'm very confident in my fair use because number one, I have a law degree, I have over a decade of experience as a trial lawyer and copyright lawyer, and I know what I'm talking about. The big businesses have lawyers who know this stuff inside and out, because the operative word here is that it is a business. And we've talked about the copyright implications, but let's talk about these sort of business law related things here. And even though I am not MxR's lawyer, and this is hashtag not legal advice, what I can say to MxR is you need a lawyer. This is a business, and you can't go around just floundering around thinking that you're going to be safe. I asked my friend Roberto Blake, who knows the business of YouTube better than everyone, what he thought about this situation, and here's what he said.
I think when you are a full-time content creator, when you have a very significant channel, like in this situation, that you have to really think of things like a business, and you have to deal with Jukin Media like a business. They aren't really going to care too much about the court of public opinion. This isn't like a YouTube drama situation where calling them out really is that meaningful. YouTubers tend to get very invested emotionally in these situations when the real answer is to step back, treat it like a business, and call your lawyer and let them deal with it, because this is a business to business situation and you really want to play your best cards. And when you take the step of just trying to out them in social media or do something like that, you're playing more the game like a YouTuber than like an entrepreneur and a business person that's trying to protect what they've built.
And that's exactly right. There are huge consequences here, and you have to lawyer up either way. MxR has says that they don't have a lawyer. Well, they need to get one. And Jeannie says that she spent half an hour going through Jookin's videos. Well, number one, that is not enough time. And number two, you can't unring the bell. Some have argued that, look, Jookin admits that the license fee is only $50. Why can't MxR just pay $200, $50 for each video, and then everyone can go on their merry way? Well, the problem is that you're dealing with copyright here. Once you have committed copyright infringement, and I'm not saying that MxR has committed copyright infringement or that they can't use the fair use defense. They may not have committed infringement, and they may have that defense. If you infringe the copyright, you can't then go back through the database and buy the license. That's simply not enough. There are statutory fees, which are potentially huge, and it costs money to get lawyers involved. So once the horse is out of the barn, you can't put it back in again. If you steal a car, you can't avoid jail time by giving it back to the owner. And it seems that MxR has already dug themselves further into the hole by not having a lawyer. They said that they already paid $2,000 to Jookin related to 2 different videos, and then Jookin came back. Well, yeah, when you feed the trolls, they come back for more.
Clearly, I realized our mistake was paying the first time, because now they're like, oh, we have someone we could just easily get easy money out of.
A competent lawyer probably would have made Jookin sign a release of all claims so that MxR wouldn't admit liability, and it would make sure that Jookin couldn't come back for more after they paid the $2,000. But because they didn't sign a release, Jookin can come back over unadjudicated claims, which is exactly what Jookin did. Additionally, a lawyer would have negotiated it down. Jookin has basically admitted that a reasonable license for these clips is $49, which would mean that MxR should pay $150, not $6,000. But the problem is that because they didn't have any foresight, they didn't have a lawyer, they didn't know what they were doing when it came to copyright, they could be liable for thousands more. Not just the $6,000 that Jookin claims, but potentially hundreds of thousands of dollars in statutory fees. Also, a word of caution to MxR. MxR has already linked to a video that takes MxR's side by a channel called The Quartering. Be very careful about listening to that advice.
I strongly suggest MxR stand up and tell him to get bent and tell him to sue him. And when they issue a copyright strike on the channel, I would dispute it, and I would say, take me to court. I don't think they're willing to do that as a company. But it's not my money.
I'm sorry if this sounds harsh, but Jookin's claim isn't necessarily facially invalid. This is a case that could go either way. What MxR has done might be fair use, but it also might not be fair use. It would be up to a judge or a jury, and reasonable minds can differ. That's what happens when you go to court. You kind of roll the dice. Certainly lawyers who I have talked to about this very case have differing ideas about it. And I would love to tell you that MxR is clearly in the right and Jookin is clearly in the wrong. I hate the way that they've gone about trying to get money from MxR, but I don't know that that's the case. I love creators and I want them to create more art, but we all have to operate within the confines of the way the law actually is, not the way that we want it to be. And it's possible, maybe even probable, that MxR is wrong. And MxR isn't quite as small as they claim. They can't stick their head in the sand. Trolls like this go out and they look for deep pockets. The thing is, Jookin has taken this to court before, and effectively they've won. We don't know the actual outcome because there was a settlement, but odds are Jookin got the better of that particular case. And even winning can be losing in a situation like this. Vindicating your rights could easily take $500,000 in attorney's fees. Just ask Ethan Klein from H3h3. It took hundreds of thousands of dollars. They went through $200,000 in 1 month to ultimately be successful in their claim. So don't assume that you can start a GoFundMe over that. Jookin doesn't care about what you think about it. A judge doesn't care about your Twitter clout or bad Yelp reviews. So just be very, very careful about whose advice you listen to. And again, the best thing you can do is talk to an attorney. And I've represented clients on both sides of the copyright coin. I've represented clients who have had to defend against meritless claims of infringement. And I've also represented clients who have had their work stolen by others and had to defend their rights. It's always a big deal and it's always messy. And as Roberto Blake said, they need to think about their YouTube channel as a business. MxR Plays gets 900,000 views on average per day, sometimes well over 1 million views a day. At a conservative CPM of $6 with the YouTube split, if monetized, their channel would get roughly $2,500 to $3,000 per day. That equates to $1 million per year. That's not a small business, that is a medium-sized business, and they need a lawyer. Now, I understand that there's a controversy about whether their YouTube channel is monetized or not, but I also understand that they have tens of thousands of patrons on Patreon. And at a minimum, if they're paying $1 to $2 per month, that means that they're earning potentially $250,000 per year just on Patreon alone. You can't get away with thinking that this is just mere YouTube drama. This is real life. The stakes are incredibly high. There are hundreds of thousands of dollars at stake here. You might end up in federal court, and this is not just a word of warning to MxR, but this is a warning to anyone with a YouTube channel. MxR says that they're worried they might have to stop reacting to videos and that they might just react to pictures instead. Number one, if you are doing things in a fair use way, then there's no need to stop. But I think they need to ask themselves whether they are very certain that they have met the fair use requirement.
And at this point, it's like, I feel like we can't even watch any videos anymore. We can't react to any videos, period.
Like, we can only look at images and pictures.
And I will say that it is just a myth that they could forego the videos and start reacting to pictures instead, because pictures are copyrighted as well, and they might run into exactly the same problems that they run into with videos, which is one of the reasons I gave a talk called The 11 Myths of Copyright on the Internet. If you're a content creator and you would like to see this free video, you can check out the link in the description. It's part of my course that I created for creators out there who don't have lawyers necessarily, but they need to be protected when they are making videos on the internet. That's why I created copyrightcourse.com. It is specifically created for creators to tell them what their rights are and to give them the tools that they need with it when they find themselves looking down the barrel of a copyright strike, potentially getting their channel deleted. It gives them the tools that they need, including the actual language that I have used as an attorney to fight off dozens of different copyright claims by underlying rights holders. I have never lost a claim because, as I said before, I know what I'm doing, and you can use the exact same templates that I use when I am fighting copyright trolls on the internet. So check out the links in the description. You can check out the free video, 11 Myths of Copyright, or you can go straight to copyrightcourse.com to get the copyright course, which I created so that other creators will not be in the same situation that MxR Plays find themselves in. So, do you agree with my analysis? Do you think that MxR is being extorted, or that maybe they committed light copyright infringement? How do you think that this would turn out in court based on the precedents that we talked about here? Leave your objections in the comments and check out this playlist over here that contains all of my other real law reviews where I talk about legal issues in the news, including impeachment and tons of other copyright related things. And check it out, and I will see you in court.